Hello everyone and welcome back to Law Statistics. Today's presentation is based on the topic CB Takeover Code. Let's proceed towards the introduction part. Takeovers and acquisitions are common occurrences in the business world. In some cases, the terms takeover and acquisition are used interchangeably, but each has a slightly different connotation. A takeover is a special form of acquisition that occurs when a company takes control of another company without the acquired firm's agreement. Takeovers that occur without permission are commonly called as hostile takeovers. Then the kinds of takeover: friendly takeover. Second one is the hostile takeover, as discussed earlier. Third one is the bailout takeover. Objects of takeover means basically the objectives: to effect savings in overheads and other working expenses on the strength of combined resources, to achieve product development through acquiring firms, to diversify through acquiring companies with new product lines, to achieve economies of scale by mass production at economical cost. Development of takeover regulations. CB notified the CB Substantial Acquisition of Shares and Takeovers Regulation 1994 in November 1994. Then the second one was in the year of 1997, which was notified on February 20, 1997. The third one was in 2011 and were notified on September 23rd, 2011. These are the three regulations. Takeover of companies whose securities are listed on one or more recognized stock exchanges in India is regulated by the Securities and Exchange Board of India. Regulations 2011. Definition: acquirer. As per to the regulation 2 clause 1 subclause A, acquirer means any person who directly or indirectly acquires or agrees to acquire, whether by himself or through or with persons acting in consort with him, shares or voting rights in or control over a target company. That is the acquisition under regulation 2 clause 1 subclause B means directly or indirectly acquiring or agreeing to acquire shares or voting rights in control target over a target company. Control regulation 2 clause 1 subclause E. Control includes the right to appoint majority of the directors or to control the management of policy decisions exercisable by a person or person acting individually or in concert directly or indirectly. Then is the frequently traded shares under regulation 2 clause 1 subclause J. Then is the identified date under regulation 2 clause 1 subclause K, and then is the immediate relative regulation. Then is the offer period under regulation 2 clause 1 subclause P. Offer period means the period between the date of entering into an agreement, formal, informal. Basically, it's the date on which the payment of consideration to shareholders who have accepted the open offer is made, or the date on which open offer is withdrawn, as the case may be. Then is the person acting in concert, defined under section 2 clause 1 subclause Q. Then is the promoter under regulation 2 clause 1 subclause H. Then is the promoter group under regulation 2 clause 1 subclause T. Then comes the shares under regulation 2 clause 1 subclause V. Then is the target company, and then is the tendering period under regulation 2 clause 1 ZA. Trigger points under takeover regulation. As per regulation 3 clause 1 of the CB regulations 2011, any acquirer can acquire shares or voting rights in a target company which, when taken together with the shares or voting rights held by him either individually or along with the person acting in concert, entitle him to exercise 25% or more than a voting right. As per regulation 3 Clause 4. Any acquisition of shares made by the promoters of the target company in an offer made by them to the dissenting shareholders pursuant to an exit offer to be given to him in accordance with Chapter 6A. Then is the Regulation 3, Clause 2 of the SAST regulations stipulates that an acquirer who along with person acting in concert has acquired and holds 25% or more of the shares or voting rights in a target company in accordance with the CB regulations, but less than the maximum permissible non public shareholding, which is normally 75% of the total paid up share capital. Regulation 4, Acquisition of Control. As per provisions Regulation 4 of the CV Takeover Regulations 2011, an acquirer shall make a public announcement of an open offer for acquiring shares of a company. Regulation 5, Indirect exercisation of shares or control. This is considered as indirect exercisation of shares or voting rights or control over a target company and are defined under Regulation 5, Clause 1. Regulation 3, Clause 3. This is irrespective of aggregate shareholding of such an individual or an entity with person acting in concert with him. Moving ahead, maximum non-public shareholding regulation under Section 2, Clause 1, Subclause O. The maximum permissible non-public shareholding in the general sense of the term is 75% of the total paid up equity shares. That's all for the presentation. Thank you and have a great